Go ahead and make the statement in contravention to what I've just told you, and I'm telling you that you will have some problems in front of me.
Judge Earl Glanville getting so heated, he threatens a defense attorney from the bench. Hi, I'm Michael Bryant, and we are bringing you this week's top 4 outbursts in the case of Young Thug out of Atlanta, Georgia. The rapper, along with 5 co-defendants, charged with a slew, that's a legal term, a slew of gang-related crimes connected to the alleged street gang YSL, also known as Young Slime Life. On the other side, the defense says, hey, YSL is actually a record label called Young Stoner Life, with themes surrounding tough life circumstances. And as somebody from the streets of Sunnyvale, California, I know tough. It can be tough. So what you just saw was the judge yelling about an argument brought on by Young Thug's defense attorney, Brian Steele, regarding the testimony of Adrian Bean. His testimony has been ongoing for weeks as prosecutors try to put Young Thug and other members of YSL at the scene of a shooting and high-speed chase from back in 2013. Now, on Bean's cross-examination, Steele wanted to ask him about an interview he allegedly had with a detective, telling him to name-drop Young Thug if he didn't want to get in trouble. Despite Bean telling Steele the conversation did happen, the actual interview is nowhere to be found, so the state doesn't want that evidence introduced to the jury. Here's more of their tense back and forth as the judge and Steele literally scream at each other.
Your Honor, on the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, it was not shown on the screen. Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to the detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is that he did in fact talk to Detective Lewis, and he didn't.
Mm-hmm. I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth. Yeah, well, that you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not. It would be a violation before me for you to put that in front of this jury.
You're not letting me finish. In the September 17, 2000.
You are saying to the court that you have a belief that there is another statement out there. There's not.
How can you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor, listen.
Go ahead and make the statement in contravention to what I've just told you, and I'm telling you that you will have some problems in front of me.
6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car? He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
But that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to it. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking what you have to find the statement for. I'm telling you the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry.
It does work that way.
No, it does not.
Yes, it does.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me.
I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to District Attorney Love.
All right, then. Well, now, lead prosecutor Adrian Love fights back over Young Thug's attorney's attempt to accuse her of deleting this interview. Watch this.
There's been no evidence, no suggestion that the state has destroyed any evidence, but they're going to ask it a million times. So that's what Mr. Steele is doing with this whole statement at the hospital. He's going to ask it a million times. So the jury's sitting there going, well, where is it? And then in the end, $100 says that he gets up there and says, they destroyed the statement from the hospital, knowing he has no evidence that one even exists. With Detective Lewis and certainly not Detective Quinn, who is the only person Adrian Bean tells Mr. Steele, at least in the portion of the recorded interview he gave me. I don't know what else he told. I don't know what Mr. Steele told Adrian Bean. But it's obvious that he's leading him through the interview that the court heard. And even being led, Adrian Bean does not let up on his assertion about Detective Quinn. Mr. Steele tries to get him to change it. You mean somebody else, other police, no, just Detective Quinn. So this idea that he has a right to ask questions that assume things that are not in evidence, that he has not put in evidence, that he cannot expect to be put in evidence is ludicrous. And to assert that the state is trying to hide something because he wants to taint the jury's mind, taint the fact finders with falsehoods, and somehow, I guess that's the way he wins cases. I don't know. But, Your Honor, I'm flabbergasted.
What is in the water in Fulton County? That is a lot of yelling in one sitting, and that is just one of two explosive arguments in the same afternoon. Earlier on, defense attorney Doug Weinstein asked the court to suppress interrogation statements of his client, co-defendant Diamante Kendrick, who was, the prosecution also says he was involved in this 2013 incident. Well, Judge Glanville ruled in the defense favor, but the lead prosecutor not happy about it, so much so the court bailiff had to step in.
Conversation.
Your Honor, at some point,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop. I was speaking.
Ms. Love. Y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
And following that argument, Attorney Weinstein gets back up on the podium to seemingly insult the lead prosecutor and the judge.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer, he invoked his right to not speak anymore, and I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
Okay, boy, that's a lot for one afternoon. I'm exhausted. Going to bring in criminal defense attorney Serena Townsend here to break this down. I could see you doing this exact same thing. You're just
Talk the
out
ears
of
off a
control.
donkey.
It's one thing for the judge to try to command his courtroom, and he's trying, but at a certain point he's got to do. He's got to drop the hammer on these folks.
He does. Obviously, they're upset with his rulings, but his rulings are his
Too bad.
rulings. It is what it is. Part of being an effective prosecutor, part of being an effective defense attorney is knowing your audience. And unfortunately, I actually think that the prosecutor had some good points and that she probably should have been allowed to bring out some of that testimony. But the way that she presented it and the way the judge was hearing it, she was never going to win. So she needed to just kind of stop.
So how do you fix this? You know, once you've set up that chemistry, that coexistence, it's hard to break that because he's going to be defensive every time she says something. She's going to be defensive. How does that work? It's like a bad marriage.
It is. And a judge is supposed to be cool and calm no matter what and not take it out on any of the attorneys. But the truth of the matter is, when you have that bad blood in there, it is hard to kind of tame it after a while. And again, in order to be an effective advocate, you need to know your audience, whether that's the judge, the jury, both. You need to be able to talk to people the right way. Whether you're right or wrong, it's all about how you present it.
And you know, this case, it continues to then continue. All of this stuff we just saw, the jury's not involved in that.
Right.
You know, it's like the jury does a drive-by every day and gets maybe a snippet of evidence. Boy, what a tough jury to be on. So God bless you folks on that jury. Hang in there. This thing could last into 2025. I'm not kidding. That's been one of the estimates. Okay, let's take a break. We'll come back more on the other side. This is Law.